Hi, and welcome to the brand new episode of The Case Study, your weekly legal fix to understand the complicated legalities of cases ongoing in the courts across the country. In the past few months, we've seen multiple women knock the doors of various high courts and even the Supreme Court of India to get their quote-unquote unwanted pregnancies terminated. A 20-year-old unmarried woman recently also approached the Supreme Court asking for the over-the-counter abortion pills to be discontinued after consuming such a pill from her local pharmacist failed to abort her pregnancy. So why are these women knocking on the doors of the court, and what does the law on abortion in India really say? This week, we will discuss this in detail. So let's start with some background first. For several decades, abortion in India was viewed as a stigma, and women opting for abortion were often socially ostracized. There were no proper laws or procedures in place, due to which hundreds and possibly thousands of women lost their lives due to illegal and unsafe methods adopted to terminate pregnancies. The law specifically allowing termination of pregnancies in India, which is called the Medical Termination of Pregnancy Act, only came into being in 1971. The Act, for the first time, permitted doctors with a particular area of expertise to terminate a pregnancy as long as it fell under certain defined conditions. In 1975, more changes were made to the law to make it simpler and more useful. The law specifically states that abortion can be carried out only and only by licensed medical practitioners. What does the law actually say? Well, according to the MTP Act, a doctor can give his or her consent to end a pregnancy at any point up to 12 weeks. If the pregnancy has exceeded 12 weeks but not 20 weeks, the doctor, along with the help of two other medical professionals, can decide on a case-to-case basis if an abortion is required to be carried out. Initially, there was no qualified right to terminate a pregnancy beyond 20 weeks. The problem with this was that several tests that are done to determine any abnormality in the fetus could only be conducted after the 20-week mark, and therefore the Act created several legal hurdles. It wasn't until 2021 that a new amendment was brought in that expanded the scope of the MTP Act to a great extent. The 2021 amendment added a new provision requiring the consultation of two or more enrolled medical practitioners if a pregnancy is to be terminated between 20 to 24 weeks. The Act also brought into purview rape and assault cases, incest survivors, married women, girls under the age of 18, women with special needs, and women with fetal malformations. Despite enlarging the scope, several categories of women were still left out of the MTP Act. Unmarried women, divorced women, and even widows were deprived of their right to opt for abortions. It wasn't until September 2022 that the Supreme Court, in a historic judgment, allowed unmarried women and single women whose pregnancies are between 20 to 24 weeks to access safe and legal abortion care on par with their married counterparts. Let's talk about this landmark 2022 judgment. A bench led by Justice D.Y. Chandrachud in September 2022 pried open the restrictive grip of a 51-year-old abortion law, which until then had barred unmarried women from terminating pregnancies which are up to 24 weeks old. The rights of reproductive autonomy, dignity, and privacy under Article 21 of the Constitution gives an unmarried woman the right of choice as to whether or not to bear a child on the similar footing as that of a married woman, is what Justice Chandrachud said. The court declared that prohibiting single or unmarried pregnant women from accessing abortion while allowing married women with the same term of pregnancy to access the care was violative of right of equality before law and equal protection under Article 14 of the Constitution. But neither the law nor the 2022 judgment dealt with the termination of pregnancies over the 24-week mark. So where do the courts come into this picture? Once a pregnancy has crossed the 24-week mark, medical practitioners and doctors are not authorized to terminate the pregnancy. It is due to this reason that many women have had to knock on the doors of the court to get their pregnancies terminated. In these cases, the High Court or the Supreme Court, as the case may be, usually directs for formation of a medical board, which then examines the woman and her pregnancy before submitting a report to the court. On the basis of this medical report, decides whether or not a woman who has crossed the 24-week mark should be allowed to terminate her pregnancy. Interestingly, in a recent case that came up before the Bombay High Court, a married woman was allowed to terminate her 33-week pregnancy against the advice of the medical board. The High Court bench of Justices G.S. Patel and S.G. Dighe said that the decision to abort the baby lies with the mother and the mother alone once the conditions under the statute are met. The termination was allowed because the fetus had serious fetal abnormalities. The High Court also noted that refusing a woman the right to abort her fetus would be denial of her right to dignity and her reproductive and decisional autonomy. The case of the 20-year-old woman who approached the Supreme Court recently is even more complicated. The woman had brought an over-the-counter pill from the local pharmacist on realizing that she had conceived. The pharmacist had told her that the pill will help her abort the baby. The woman, unaware that the pill had no effect, assumed that her pregnancy was aborted and didn't realize she was pregnant until 29 weeks had passed. As a result, she had to approach the court to get her pregnancy terminated. It is due to this reason that as part of her petition, she has asked for the court to issue clear directions banning over-the-counter abortion pills from being supplied by local pharmacists. The court had asked for her medical examination to be conducted, and her plea regarding the abortion pills is still pending before the top court. Thank you for watching this episode of the case study. If you like this video, please hit the like button and don't forget to press the bell icon and subscribe to Law Today for more updates about what is happening in the legal world. If there are any specific cases that you want us to cover as part of the case study, please leave your suggestions in the comments section below and keep watching Law Today.